We are here to talk about the new bill that went into law July 1st. I just want to say when we get started, there's no CE credit for the class, so you don't have to worry about that. And also, if you have questions, you can ask questions, but we're not here to state our opinions on whether or not we like the law, okay? It's a very controversial subject, so we're not going to delve into that. If you have an actual question that can be answered, that's fine, but please refrain from stating your opinions. And then if questions are asked in the room, we'll just need to repeat the questions so that those on Zoom can hear the questions.
Do my best.
All right, thank you so much. Take it away.
All right, good afternoon, everybody. My name is Bill Morris. I'm an attorney practicing law here in Collier County. I'm also the board attorney for the Marco Island Area Association of Realtors. We're going to talk today about Senate Bill 264, which also had a companion House bill. They adopted the Senate bill, and it became law on July 1st of this year, signed into law by Governor DeSantis. This was a pet law from Governor DeSantis, and it deals with foreign principals acquiring interests in United States, in Florida real property. So what I'm going to do today is probably relatively unique to this approach. I'm going to go through the statute with you so you actually get to see the statute. Too often, I think, we tend to dumb things down for realtors thinking they can't understand the law. The law is too complicated. You have to have a lawyer. But we're going to go through this. So this will be like a mini law school class. I'm going to go through the statute with you, which I haven't seen a presentation do that yet. That way you'll have a background for the statute. You'll understand the statute. You won't have to remember everything I tell you. You'll remember the bottom line about the statute, but at least you'll understand what it does and who it affects. And it may affect you as part of your real estate practice. So the first thing we're going to talk about is this amends section 692 of chapter 692 of Florida statutes. The statute dealt previously with conveyances by corporations and not-for-profits, and now it deals with conveyances to foreign principals. There's a definitional section that's been added. Now the definitional section, this addresses all of the types of properties that foreign principals are prohibited from acquiring. So that's why I'm going to go through this with you. The first one is agricultural lands. It references another statute to define what agricultural lands are, but the primary idea of agricultural lands is that it is property that is actually being used as farmland for agricultural purposes. It's not just vacant land. And the litmus test for that is, what is the property appraiser classified the property as in the county where it's located? So if it's ag for zoning or for classification for property taxes, then you can pretty much count on that it's ag for purposes of this statute, okay? Critical infrastructure is another special type of property, and critical infrastructure means any of the following if, and if is a big deal, there are fences, barriers, or something else put up in order to impede access or restrict access. So we'll go through a lot of these you're not going to worry about because they're not local, but they are in the state of Florida. A chemical manufacturing facility, a refinery, an electrical power plant. We've taken the statute itself references another statute to tell you what electrical power plant is, and we've put that in for you. The electrical power plant means any electrical generating facility that uses any process or fuel, and it is owned or operated by an electric utility, okay? And again, remember, these are only facilities, infrastructure, that there's a fence or something else that impedes access. Water treatment facility or wastewater treatment plant, a liquid natural gas terminal, telecommunications central switching office, a gas processing plant, including a plant used in the processing, treatment, or fractionization of natural gas. So think about all these different categories. Just in the critical infrastructure alone, we're starting to take up a lot of the state of Florida just for these facilities. Okay. A seaport, and a seaport is basically a large port. You're thinking about Miami, Jacksonville, places like that where cruise ships come in and out. I'm not going to go through the whole list here, but we really don't have a seaport in Collier County. But again, in case you're showing property or dealing with property outside the area, you need to know it exists. Another thing we don't have in Collier County is a spaceport. And interestingly enough, if you look at the section of the statute, it references 331.303, section 18 of Florida statutes. And if you look at that and 304, you'll see that there are spaceports in a lot of places that I didn't even know about until I read the statute. We've got Cape Canaveral, everybody's heard of that. But we've also got John F. Kennedy, which was Cape Canaveral. We have a spaceport station Patrick Air Force Base is a spaceport. And we've got Brevard County. Down in 2, we've got Santa Rosa, Okaloosa, Gulf, and Walton County. So there's more than just Cape Canaveral as a spaceport in the state. Spaceport's territory expands on that. We've got Duval County, the Cecil Airport, the Cecil Commerce Center. So the point of explaining all of this to you is, again, to let you know that you may think you know what the statute says, but I don't know that you can, and I don't want you carrying the statute around to look at, but it exists, and there are all these things in there that are critical infrastructure. An airport is critical infrastructure, and airport's defined by statute as being any area of land or water designed and set aside for landing and taking off of aircraft. We have one of those right up the street from Marco Island. We have one of those in Naples. We have one of those at Fort Myers. And you'll see eventually that these people are prohibited from acquiring property within 10 miles of any of these things. Okay? So it broadens the rest of the state. I'll get to questions at the end, okay, if you can try to hold it for me. You don't want me to lose track of what I'm talking about. Easy enough to knock me off base, okay? Now we look to the next thing. That's critical infrastructure. What's the next thing the statute defines? And that is, not all foreign people or foreign principals are prohibited from acquiring Florida real estate. Here's the countries from which the foreign principals are involved that are prohibited. The People's Republic of China, that's China. The Russian Federation, and these are the proper names for the countries in case you didn't know. The Islamic Republic of Iran, the Democratic People's Republic of Korea, the Republic of Cuba, the Venezuelan regime of Nicolas Maduro. Not Venezuela, but the Venezuelan regime of Nicolas Maduro. Those of you who read the paper know that Nicolas Maduro is not particularly kind to the United States. He's very much anti-U.S. Or the Syrian Arab Republic, including any agency or any entity of significant control of the foreign country. So those are the countries that we're worried about. Then the statute defines what's a foreign principal. So this just isn't a foreign entity. It's a foreign principal. So the foreign principal means the government or an agency of the government of any of those countries, a political party or a member of a political party of one of those countries. Think about that. So I think everybody in China is a member of the Communist Party of China. Probably in Russia, you get all these people disqualified. A partnership, association, and this is where you're most likely to have a problem. Partnership, association, corporation, organization, or other combination of persons organized under the laws of or having its principal place of business in a foreign country. Any person domiciled in a foreign country of concern that is not a citizen or lawful permanent resident of the United States. And then any person, entity, or collection of persons or entities described in all of those paragraphs having a controlling interest in any other entity. So you see, it's pretty broad. Okay. Military installation, we have those in Florida. And yes, I think it also includes the National Guard Armory. So we've got base camp, post, station, yard, or center encompassing at least 10 contiguous acres under the jurisdiction of the Department of Defense. So think about all the National Guard armories you see around the state of Florida. And real property is, if you need to know what that means, it means land, buildings, fixtures, and all other improvements to land. So now those are the definitions that we're dealing with under the statute that prohibits foreign principals from acquiring interest in land within certain proximity of those places or in agricultural land. The statute actually prohibits them from acquiring agricultural land altogether. Okay, so let's look at agricultural land. That's the first category in the statute. A foreign principal may not directly or indirectly, so think about that, indirectly or directly, may not own or have a controlling interest in, acquire, or by purchase, and there's a whole list of things there, agricultural land. A foreign principal has a de minimis indirect access if the foreign principal basically by stock in a corporation that's traded on an exchange, and they have less than 5% of the stock in the corporation, okay? Or a non-controlling interest in an entity controlled by a company that is both registered and domiciled in the United States. So just because a foreign person is involved with something doesn't mean they're disqualified. Certainly if you become aware that anybody from any of these countries is involved, you need to get an attorney involved right away. Okay? A foreign principal that directly or indirectly owns or acquires agricultural land or any interest in agricultural land before the effective date of the statute, which was July 1st, 2023, can continue to hold that land. Okay? but may not purchase any additional land. So if you come across someone that does own the land, already own it, and they want to expand to it, they can't do that. However, the other thing that's important, it's not in your wheelhouse, but it's again time for you to tell them they need to talk to an attorney. All of those folks have to register with the Department of Agriculture and Consumer Services by January 1, 2024. We don't have a lot of time for them to do that. So if you had any customers that are involved with this or had any opportunities there, it might be time to reach out to them to give them protection. And you'll see in the statute, there's a whole list of information that the foreign principal has to provide to the state. Okay? If they don't register in time, they're subject to a penalty of $1,000 a day. And it's kind of a sneaky way to think about that if the foreign principals don't register and the state's not going to take their land, because one of the ways that they wrote this statute to try to pass constitutional muster as opposed to taking property is you can keep it if you own it, but you can't buy anything more. But if you don't register, then it's going to be a $1,000 a day fine. Well, that can happen, and then if the fine mounts up, the state will take the property because they didn't pay the fine. Okay. Now, if you look at this exception at number 4, this exception appears in all 3 categories of property. And that is that a foreign principal can acquire an interest in agricultural land, but only through inheriting it or by collecting a debt. So if it's a foreign principal that has a mortgage on property and forecloses and ends up with title, they can do that. Okay. Then if they do that, now that they own it, what do they have to do? They have 3 years to get rid of it. So there's a listing for you. Okay? You become aware of anybody that's acquired property for an inheritance or whatever. It's not a bad idea if you do know anybody that might fall within the statute, if you reach out to them for marketing purposes, because if such time as they pass away and their kids inherit it or whatever might happen, their kids will have 3 years to get rid of it. Well, there's a listing. Okay? Now, how is the government think this is going to be enforced? Well, Section 5 of this section of the statute has the same requirement as the other 2 sections, and that is, at the time of purchase, the buyer must provide an affidavit signed under penalty of perjury that they're not a foreign principal and that the purchase is in compliance with the statute. Okay. Now, should you be involved with providing those affidavits to these people? I don't think so. Keep in mind that when I give you advice, it's my advice, not that of your broker. So you might want to talk to your broker, but I don't think you want to get involved in talking about the affidavit or anything else. I don't think that's in your area of expertise. Your area of expertise is assisting people in purchasing or selling real property, not in dealing with this statute or any other statute. It has to do with particularly filing or submitting an affidavit. Who's going to do this? Certainly at the closing, attorneys are going to do that. And we have that. And all the title insurance underwriters that I'm aware of have sent out proposed affidavits. Now, state is supposed to draft an affidavit form. Does anyone here, this is a rhetorical question, anyone here know how long it will take the state to draft the affidavit form for the statute that already exists that says the state's supposed to have the affidavit form? Just by way of explanation, when FIRPTA became effective, it took the government over 3 years to prepare a particular form in connection with FIRPTA. Now, that's the federal government. Of course, Florida is much more efficient. Don't count on it. We do have some affidavits floating around, and they're all going to work just fine. There's no magic to this, but they're out there. So the other good news is, as long as you don't violate the statute knowingly, then you're not going to have any liability. Okay. However, the problem is, ever watch any TV show where the government goes out and arrests somebody, and they throw the net pretty broadly, and they arrest a dozen people because they all kind of hang around and associate with everybody? So you don't want to be that person who's associated with the person who gets arrested. So you need to be vigilant. Okay? Okay, so agricultural land, to show you what happens if the violation, not only can the state forfeit the property if somebody acquires title in violation of the statute, so you don't have to worry about registering because you inherited it. If they buy property and the state finds out about it, it can be forfeited to the state. But it's also a misdemeanor of the 2nd degree, okay? And therein lies the rub for you if you're involved with the transaction, because you can be guilty of the same violation of misdemeanor of the 2nd degree. In addition, any complaint with FREC and ethical violation. So a 2nd degree misdemeanor is punishable by imprisonment for not exceeding 60 days. and a fine of $500. So it doesn't sound like a very hefty penalty, but still one I think you'd rather avoid. Okay. All right, so that's agricultural land. So there's a complete ban on agricultural land with the exception of inheriting it or taking it through a collection process. Okay, everybody's aware of that. Okay. So let's move on to critical infrastructure and military installations. So that's a little different than agricultural land because I talked about that, and I think the way to tell if it's ag is property appraisers listed as ag, it's ag. Now, you certainly can go out, and if you see somebody pulling a tractor, plowing a field, planting plants, even if it's not listed as ag land on the property appraiser's website, I think it's ag land, okay? So be careful with that. But now, we've got all that agricultural land that's problematic for somebody to buy if they're a foreign principal. So what else are they not supposed to buy? Not property, if you look at this, not property that's within 10 miles of a military installation or critical infrastructure. And that's why we went through that long list of critical infrastructure and military installation. You know, utilities, airports, water treatment, sewer. And I don't think I've seen a water treatment or sewer plant that doesn't have a fence around it. It doesn't have to be much of a fence, anything at all. And I think Wings, somebody told me Wings has a fence around it. Wings Air Park here in Naples, that has a fence around it, okay? So you can't get in there because they're impeding access, so that qualifies, in my opinion, as an airport. So 10 miles from Wings. Now, if you've got a foreign principal, that pretty much, between that, Naples Airport, Marco Island Airport, that pretty much takes care of most of the county, I think, okay? So we've got that problem, okay? So, same exception in the statute if they own an interest or acquire an interest in a publicly traded corporation, that kind of thing, and you guys aren't going to be dealing with that, so that's not really important, okay? Now, if they do acquire, it's the same as the other, the ag land. If they own land that's within 10 miles of a critical infrastructure or military facility, they can continue to own it, okay? But they have to register with the state. Only this time, they register with the Department of Economic Opportunity. Now, you don't need to remember who they register with, but as I said, if you had a customer that you think qualifies as a foreign principal, you may want to reach out and just say, hey, you may be interested in this new statute, okay? And they have to do that by December 31 of 2023. Now, don't ask me why the deadline for this section is December 31, 2023. Deadline for the other two sections is January 1, 2024. But if you've ever watched the legislature make new laws, it's kind of like making sausage, so it comes out, and then after it's out for a while, they go back and fix it. I have a hunch this one will be fixed, okay? So it's late, but in this statute, they say that they define when it's late. It's not late till January 31, 2024, okay? So they've got to register, and if they do that, then they're okay. Now, notwithstanding those restrictions, here's where there's an opportunity for you. If the foreign principal is a natural person, they may purchase one residential real property up to 2 acres in size if all of these conditions are met. 1, the parcel is not on or within 5 miles of a military installation. The person has a current verified United States visa that is not limited to authorized tourist-based activity, okay? And that the visa or document authorizes the person to be legally present in Florida, and the purchase is in the name of the person who holds the visa or documentation. Okay, now, unlikely that you're an expert on visas and documentation, so this is once again an area that you refer to an attorney so that you don't get in trouble and your customer doesn't get in trouble, okay? And again, at subsection 5 of this statute, we have the same exception as we did for ag land, and that is that for this property, you know, a foreign principal can acquire the ownership if they acquire it by inheritance, which is devise or the other language in there, or in collection of a debt, but they have to get rid of it, once again, within 3 years. Okay, so there again is another one of your opportunities for listing, okay? And how do they enforce this? How are we going to make that work as a real law? Once again, we're going to have to get the same affidavit from the buyer in connection with the purchase. And again, I tell you, I don't think that's your job. I think that's up to the closing attorney to make sure they're doing that. If they do violate the statute, The violation is a misdemeanor, second degree, just like the ag land violation, okay? Punishable by the same punishments. So far, we've been through agricultural land, and we've been through critical infrastructure and military installations. Everybody keeping up with all that? Pretty exciting, huh? But we saved the best for last, and apparently the legislature and Governor DeSantis really have it out for the Chinese. So there's a separate section under this statute that deals with Chinese foreign principals, okay? And it's got a fairly comprehensive list of who is considered, who qualifies as a foreign principal, right? The People's Republic of China, Chinese Communist Party, or any official or member of the People's Republic of China or the Chinese Communist Party, any other political party or member of a political party in the People's Republic of China, a partnership, association, corporation, organization, or other combination under the laws of its principal place of business in the People's Republic of China or a subsidiary of such entity. So it could be a company in China that's got a subsidiary in the United States. Subsidiary in the United States is disqualified. Okay? Any person domiciled in the People's Republic of China who is not a citizen or lawful permanent resident of the United States, and any person or collection of those disqualified that create any or become part of an entity is also prohibited. So that's a pretty broad paintbrush for the Chinese. They're prohibited from acquiring any real property in the state of Florida, with the exception of the carve-out for the 2 acres used as a personal residence by the person who's going to take title, okay? It's not within 5 miles of a military installation, and the same criteria here is for the exception under the critical infrastructure and military installation for other foreign principals. They either have to have the proper visa or documentation showing that they're legally here in Florida, not tourist-based, and the purchase has to be in the name of that person. It can't be in somebody else's name, so it has to be in their name, and they're the ones who take title. Okay. And if any of those people do acquire title, they have to register with the Department of Economic Opportunity. Okay. Anybody who inherits property or takes it by enforcing a debt, they are allowed to, if you inherit it, do that. You still get to keep it, but you have to register if you inherit it by December 31, 2023. And if they acquire it later, because remember there's the 2-acre exception, the Chinese buyer has to register with the state within 30 days after acquiring title. Okay. So the registration is a big deal. Okay. The same penalty applies, $1,000 a day for any violation of the failure to register. Okay. And then we move on to subsection 5, which is the exception, which is in the other 2 sections, that if they can get this property, if they get it through inheritance or by enforcement of a debt. Under section 6, same requirement that when somebody buys a property here, you must get the affidavit, not you, but the closing attorney must get the affidavit that says that they qualify, they're not a disqualified person, that the transaction does not violate the statute. And this is the statute, this statute is the one that has the felony in it, so it again shows you how serious they are about this particular classification. It's a 3rd-degree felony, which is punishable, and this one is a little more painful. Imprisonment not exceeding 5 years, $5,000 fine plus court costs. And if you do it more than once, you can have an enhanced sentence. So again, I have found that realtors that get in trouble often get in trouble by chasing a dollar. The concept of greed is a very dangerous concept. So if you've been a few months since your last sale and you have an opportunity here to help somebody out, think about it. The penalty here is pretty bad, so you need to be careful with that. The person who knowingly sells property, the penalty for that, it's a 1st-degree misdemeanor, and that's imprisonment up to 1 year and $1,000 fine. So the sellers also have issues here. The sellers are, I don't know how many sellers are going to be aware of this statute, so they're really going to have to rely on who's ever doing the closing to make sure we keep them out of trouble. Now there's an exception which I don't think is going to come into play in our market too much, but it might more in Miami because there's an awful lot of diplomatic stuff going on in Miami, That is, that if property is acquired for diplomatic purpose that is recognized and acknowledged by the federal government, then it's not subject to the statute. So if you're planning on working in the Miami area, first thing I tell you is don't. Second thing I tell you is if you're going to, get somebody in Miami that knows what they're doing to work with you, because we not only have to worry about this statute, Miami has a lot of local regulations and ordinances that you can trip over without even realizing it. So it's a tough place for us to close deals. It's a tough place for you to do real estate business in. If you're not familiar with it, either refer or associate with somebody that's there that's a pro, okay? Now, this is kind of a dangerous statute, so NABOR's Legal Resources Committee was kicking around what to do about it. And while we were kicking it around, the FAR Bar Committee was also kicking it around, and they got through kicking it first. So the FAR Bar contract recently came out, and it's got this disclosure language in the contract. Now, why did they beat Legal Resources to getting something done? Usually, FAR Bar is more like a brontosaurus rolling through, and NABOR is more akin to a velociraptor, although it may not feel that way, because we move a little quicker. We're not all over the state having to get together periodically, try to meet by Zoom, do these things. We've tended to move much quicker than FAR Bar. However, in this case, the Legal Resources Committee felt that we were really torn because if we thought if we put disclosure language in the contract, what was that going to do? That was going to open the door to the discussion by a realtor with a customer. And we were real concerned how that discussion was going to go and put you in a bad position or in violation of fair housing laws. So we weren't in a rush to put this in the contract. When it came out in the FAR Bar contract, Legal Resources revisited and thought, you know, it's there, we might as well put it in there, we might as well put a disclosure in. So we asked the FAR Bar Florida Realtors if we could use the language out of their contract so we didn't have to reinvent the wheel. We thought that was decent language. They said yes, so the same language is going to be in both contracts, and there's another good reason for that, because now it's consistent no matter what contract form is used. And as you know, some of the larger brokers still use the FAR Bar contract. If somebody comes over here from Miami, it's easier to come over from Miami than it is to go to Miami, okay? So they come over here, they bring the FAR Bar contract with them, so this language will be in there. Now, should you be explaining this language to your customer? I don't think so, and I highly recommend against it. And I'm the only attorney on Legal Resources, I think about the only real estate lawyer in the county that does lawsuits. So my primary purpose on that committee is to keep you all out of hot water. And I'm always talking about how it looks in court and why that looks in court and how this is going to be. And from day one, I said, don't put our people in a position that they have liability. Don't put them where they're going to have a question. Don't put them where they say things. Don't put them where they're asked a question, because NAR and FAR make you out to be experts, and you are, but often not about the question that your customer asks. And there's a temptation to answer that question so you continue to look like an expert. Okay? If you do get questions, it happens in my own practice. I do not practice all areas of law. I'm not a bankruptcy attorney, and I'm not an advanced tax attorney. When I get those issues, I will refer them. I'll tell my client, I do not know the answer, but we're going to go find it. We'll find somebody that does. And I think nothing makes you look like more of a professional than referring to somebody who knows an answer than the opposite, which is, anybody here ever know somebody that knows everything, no matter what it is? One of my kids was like that for a while, and he knew everything. No matter what it was, he knew what it was. Of course, he knew very little. Eventually, your customers figure that out, right? You have the answer for everything. So you don't want to be that person. So build a network and always be able to refer to an expert that covers what you don't do, which is buying and selling real property, okay? So this is the language. If you want to look at it, all you have to do is look at the FAR Bar contract. We approved it on Legal Resources. I believe it's going to be in the NABOR contracts, but it takes somewhere between 3 and 5 weeks before it comes back out because of all the vendors that those contracts appear on. And they'll have to coordinate and they'll get released at the same time. So it's not just like, boom, it's in. We have to get that all done, okay? So that's the new language. Now, the other topic I'm not going to address in any great detail, in fact, no detail at all, but I want you to be careful. The biggest problem with the statute for a realtor is fair housing issues. Because I don't want you to ask somebody who looks like they might be Chinese if they are Chinese. Or are you Iranian? Are you Syrian? Okay. Are you from Cuba? Are you Cuban? You know, these are not the questions you are supposed to ask. In fact, if you do, you'll get in trouble. I would not be surprised if we find testers in our market trying to come around and see if they can get realtors to ask those questions. Okay? We get testers all the time on other issues in fair housing, so this is something that's just another category. And there are a lot of people going around with nothing better to do than look for cause trouble for other people. So this is an area that you might have some liability. Be really careful with this. This is why Legal Resources didn't want to do this right away. And we're doing it because we didn't want to have some contracts with language, some without, so here it is. But be careful of this. This is a big issue. And I think you need to be really worried about it, okay? So the last thing we've got on the PowerPoint, anybody that wants my PowerPoint, I'll be happy to send it to you if you just tell me what your email is. I'll give you my email if you want to write it down. My email is wgm@wgmorrislaw.com, wgm@wgmorrislaw.com. So if you email me, I will email you this PowerPoint if you want it. And these are two flow charts that were nicely provided by Florida Realtors. And it shows you effectively the statute. It really summarizes things, not in the detail that I would like on here, but it gives you a pretty good idea. But I think the key here for you is to realize that Chinese foreign principals are barred from everything, with the exception of the 2-mile carve-out, as long as it's not within 5 miles of a military installation or critical infrastructure. And then foreign principals are barred from ag land altogether. And then we're barred from anything within 10 miles of a military installation or critical infrastructure unless it's that 2-mile carve-out for personal use by a person who's legally here and has proof that they are. All of those things are not in your wheelhouse, but just so you know that they're there. That is why we don't ask them if they're Chinese or Syrian or Iranian. We let the closing attorney do that and get in trouble with it, okay? Because once they've signed the contract, I think we're through the fair housing issue. But I don't want you, as soon as they sign a contract, saying, now that you signed the contract, are you Chinese? Okay. That's the way these things go wrong. That concludes my presentation, a little quicker than I planned on. But do you all have any questions? You did have a question. Somebody back there, and I said, yes.
I heard you say that Wing Park, I guess you were talking about Wing Park South as far as
Yes.
being an airport.
Yes.
Okay. Brixham Park up in Lee County is also an airport. It does not have a fence, but it is, however, an airport. Airport community.
Right.
It's a strip of, it's just a runway.
Well, the statute says if it doesn't have something around it in some fashion to impede access, that doesn't necessarily have to be a fence. It could be a moat. It could be a berm. It could be anything that you could look at and say, yeah, that's supposed to keep people at least from going right in there.
Only that it keeps the members. You have to own a house in the airport.
Right, but if there's no structure impeding access, so if that was a gated community, it is a gated community. Okay, well then they're impeding access to the airstrip, because to get to the airstrip you have to go through the gate to get to the airstrip. Well, but you see, that's for users that they're impeding the general people from coming in. So I think that since they've got the gate, I think that's going to qualify as an airport under the statute. Okay. Anything that impedes, just you and I walking out there.
Secondly,
Excuse me one second. For the people on Zoom, the question was, what's the name of that air park?
Brixham Park.
Brixham Park in Fort Myers. There's not a fence around the park. It's kind of like Wings South is in Naples, I gather. But there is a gate. It's a gated community. And the question is, would that qualify as an airport underneath the statute? My opinion is it does, because the gate is intended to impede access. Now, admittedly, the gate also impedes access to the houses and the community and everything else, but clearly it impedes access to the airstrip.
I work for a fairly large brokerage. We were encouraged to have the affidavit signed before the selling process begins. As soon as we meet somebody that says, hey, this is the new Florida law, are you saying that is, you would recommend against that?
Well, this gentleman said that he works for a large brokerage firm that wants their agents to have the affidavit signed before the contract is signed. And I assume first contact, perhaps?
Before the buying process begins.
Okay, so as soon as you meet a customer, you have the affidavit signed, okay? That's probably safer than anything else. The reason I don't like doing any of that by agents is because if you don't know that the buyer is a foreign principal and you're facilitating a transaction, you have to know that you're violating law in order to be criminally liable, okay? They have to prove what's called mens rea, which means you have to have that mental knowledge that you are violating the law. Otherwise, there's no intent. You've probably seen that on your crime shows on TV. Anybody ever watches those or movies? So without intent, you're good. So my fear is violating fair housing laws because I think that's an easier stumble than it is to have something signed. So if your broker says, we want these done, you've got to do what your broker says. But you've got to be very vigilant then to make sure that you're not having that discussion that crosses the line into a violation of the Fair Housing Act. So that's where my fear comes from. I'm worried from a liability standpoint, as a litigator, I'm more comfortable defending you saying, this guy didn't know that the person was Iranian or Syrian or a foreign principal of any kind. Got a contract, came in, we found out later. I'm more comfortable. Now, why would your broker want to have that signed before anything happens? Because does it really want you wasting your time with a buyer who's not going to be able to buy? I get that. That makes sense. But I really worry about defending you in court more than I worry about you spend some time driving around with somebody, which you all do all the time anyway, sadly. My father was a broker for over 30 years, so I heard plenty of war stories.
And then if somebody on the 3 years, well, I guess my first one is if you know that you have sold property within the past, say, 2 years, somebody of one of
A foreign principal.
do I have any responsibility to let them know this new law?
Okay, the question is, if you know that you sold a part of a transaction in which a foreign principal acquired Florida real property in the past few years, is there any obligation on you to tell them about this new law? From a legal standpoint, there's probably not any such obligation. From a moral, ethical, and do I want to get business from these people because they have to get rid of this property someday? Maybe, okay. But that again, I don't want you to get in trouble because when you do get in touch with them, if you do anything more than say, here's a new law you may be going to want to know about, and if you have questions, please consult your attorney. Now you've become the lawyer going to explain the law to them, and that's where things go south again. So be really careful with that.
Okay. And the last question is on 3 years of inheritance, or if somebody passes away or uses the debt, they have 3 years to sell the property. If they are in the process of going through citizenship or getting married to get their citizenship or doing anything, is there anything that would cover them on that?
The question was, we got the 3 year to divest if you've inherited it or acquired it as part of a debt collection. And if the person who acquired the property is in the process of becoming a U.S. citizen one way or another, is there anything to delay the implementation of that 3 years? You've got to get rid of it. Not in the statute as it's currently written. But we have 3 years to figure that one out. So the legislature may address that later. Anybody else? Jeanette, any questions?
Yeah, it's from Diane. And Diane's question is, by not showing the property to a buyer by not showing a property to a buyer because of this new law, is that considered redlining or steering?
Well, that's my concern. Fair Housing Act, right on point. So that's why we go back to the broker says give them the form before. I'm saying I don't know. That's my real fear is that we're going to have that, and we're going to have testers because this is just a great opportunity for somebody who wants to cause trouble for somebody else to come in and do that.
Thank you.
Is that it? All right, folks, we're done. It was a pleasure seeing you all, and those on Zoom, I hope you all have a good day. Thanks for coming today.
One more question.
Yeah.